The South Dakota Worker Compensation Report is brought to you by theemploymentlawreport.com and by Workers' Comp Boot Camp. Links can be found below this video. You can also find us at southdakota.workerscomplaw.com.
Hi, this is South Dakota Workers' Compensation Attorney Eric Blomfeld, and I'm talking today about a new case from the South Dakota Supreme Court, which is called Thyen, Thyen, versus Hubbard Feeds, Incorporated. The Supreme Court decided it on September 21st, 2011. And here's what the case was about. There was a gentleman who was working at a feed mill who had some kind of allergic reaction to the feed or some contaminated feed or spoiled feed that he was working with, or at least that was his suspicion. He went to a variety of doctors trying to figure out what was wrong because he was having terrible symptoms of a red face and difficulty with other body parts and just really seemed to be having an allergic reaction. Well, the doctors couldn't figure out what was wrong, and they wanted to test some of the grain that he was exposed to at work to see if they could confirm their suspicion that this was in fact a work-related problem about exposures to chemicals or some other contaminant. So they wrote prescriptions asking for the employer to provide to them some samples from the workplace so that they could test them and determine whether or not this was in fact a workplace exposure problem. But the employer didn't provide the samples, at first saying that there were no protocols for how to collect them, but even after receiving a list of protocols, the employer still didn't provide the samples. Eventually, the employee returned to work, but in doing so, the employer had him sign a letter that said basically if you take anything out of the workplace, you're going to be fired, to try to, presumably, to try to prevent him from taking samples on his own. Well, the case went before the Department of Labor, but without those samples and all the doctors wondering what really happened to him, the employee was not able to prove his case. He couldn't prove that the problems that he was having was the result of workplace exposures to the grain and feed. And in fact, the Department of Labor said all you have is a temporal sequence that says, hey, I got sick and I got sick at work, so therefore it must be work related. And that wasn't enough according to the Department of Labor. Well, the employee appealed and it went to the South Dakota Supreme Court. And here's what the Supreme Court said. The Supreme Court said we need to have another hearing in the Department of Labor level. And the reason is because of this concept known as spoliation of evidence. What the employee argued was, hey, I couldn't prove my case because the company wouldn't provide me with the samples, and therefore I had no evidence. And it was their fault that I couldn't prove the case. So I should get another chance to prove that they spoiled the evidence. Well, the employer defended this, saying that, look, you didn't raise this issue specifically in front of the Department of Labor, so you can't bring it up now. But the Supreme Court said that, hey, even though the employee didn't use the exact word spoliation, he still made it an issue at the Department of Labor level sufficient for this to be overturned and sent back to the Department of Labor for a new hearing. You can read more about this case in the South Dakota Workers' Compensation Report in the fall 2011 issue. And if you'd like to receive more updates like this from us, just please sign up below, sign up on our website, and you can unsubscribe at any time. But when new cases come about like this that we think are important that you should know about, we'd be happy to send you a short video like this in a newsletter or an email communication so that you can stay up to speed on South Dakota workers' compensation law. Thank you very much.